Hello, welcome. I see we've got people joining us here. Fantastic. Thank you so much for joining us today for this webinar, Indian Law Update 2023 with Mark Vezzola, General Counsel for Pechanga Tribe here in San Diego County. And I'm going to do a little bit of housekeeping before I turn things over to Mark here. Just to let you know, I know some of you, maybe all of you are here looking for CLE credit today as well as learning. So we will be sending out CLE certificates by email later this afternoon. I'm just going to need to verify who attended in the Zoom report before we do that. So that's how you should be getting the CLE certificate. This is also an interactive session. You will have a chance to ask Mark your questions. And the way we will ask you to do that is to use the Q&A feature here in Zoom. You'll see an icon on your desktop there or on your device if you're using a device that says Q&A with 2 speech bubbles. You can just click on that, type a question, and you can do that either under your name or anonymously, your choice. And then hopefully Mark will have time to get to those at the end of the session. And then finally, I wanted to mention that there will be a link to a survey that you will see when you're leaving the session today. We would greatly appreciate if anyone would take the time to answer the survey. It's just a few questions and helps give us feedback for future presentations. So I think that's all I had to say. And with that, I will go ahead and turn things over to Mark.
Thank you, Lisa, and thank you to the San Diego Law Library for the opportunity to speak with you today a little bit. Let me share my screen here. Okay, so we're here to talk today about federal Indian law, but it's kind of a year-end review because there have been quite a few significant developments in this area during 2023. Some of them maybe you heard about, some of them maybe not. A few are kind of obscure, and I think we can get started. Okay. So as Lisa mentioned, my name is Mark Vezzola. I am Deputy General Counsel for the Pechanga Band of Indians. I just want to share a little bit about the tribe and acknowledge that I am speaking to you today from Temecula, from the tribe's ancestral homelands, which it still occupies. We are in Temecula Valley, and this first slide here is just giving a very, very brief and general overview of the kinds of things that are going on up here at Pechanga. The tribe has a very rich history, as well as a very clear commitment to cultural resource protection and activism to protect tribal sovereignty, not only its own, but for other tribes as well. And you can just see here an overview of the tribe's resort and casino building. Down the street from me, I work at the tribal government building, which is on the reservation off of Pechanga Parkway. And then going clockwise, we have an image of the great oak. It's over 1,000 years old, and it's kind of a symbol here at Pechanga of strength and endurance and perseverance. And it reminds people literally and I think figuratively of their roots. And in the bottom corner, some examples of Pechanga basketry. But I've been at Pechanga now for going on 9 months. It's relatively new, and I enjoy it a great deal. There's a lot of work to be done here, a lot of good work that's already going on that I've been allowed to be a part of. So someone asked me if I would share a little bit about my role at Pechanga. In other words, what I do on a day-to-day basis here. So the Office of General Counsel at Pechanga is really legal counsel to the tribe itself. And the Pechanga Band of Indians is a sovereign tribal nation. There are 574 federally recognized sovereign tribes across the country, of which Pechanga is one. We're located here in Riverside County, just north of the San Diego County line. But my role here, our role in the Office of General Counsel, is to assist the tribe and tribal council, which is made up of elected officials who oversee the day-to-day operations here, with its legal issues. So we, in the Office of General Counsel, interact with various departments that make up the tribal government, with the tribal council itself, as well as the various business entities that Pechanga is involved with. Our casino, our leased commercial space here on the reservation, many other issues. We do interact directly with tribal members, although we don't typically represent them directly. We can provide general information, referrals when we can't assist them ourselves. My work generally falls into one of three categories. There's always new and exciting things popping up. But I do play a role in helping the tribe draft and revise its policies and ordinances, tribal laws. I work closely with the tribal court, not as an advocate and not as a judge or a decision maker, but helping the court develop its policies, its rules, its procedures, because our tribal court is still relatively young, maybe about 6 years old at this point, tracing it back to the adoption of our judicial ordinance. I work closely with the Pechanga Tribal Rangers. That's our law enforcement body here on the reservation. I help them with issues relating to restrictions and exclusions from the reservation, their own internal policies, and then Pechanga Child and Family Services, which is the agency that houses our social workers to protect children, child members of the tribe. And that is also an issue that we're going to be talking about today, because there have been some significant developments, not only within California, but across the country in terms of Indian child welfare. So we'll get to that in a moment. And then I also work closely with people who are seeking some kind of orphan or child support from tribal members. And you can see the picture on the right, my right. I do get dunked on occasion. So that photo was taken of me in a dunk tank at Pechanga's Earth Day festival back in April. And keep in mind, I think I was still in week 1, maybe week 2 here at Pechanga when I was asked to be dunked. And I said yes, and it turned out to be a lot of fun and a great event. That young boy in the photo had an arm on him. I was repeatedly dunked, which made it all the more fun. They actually announced on the loudspeakers that there was an attorney in the dunk tank, and the line just kind of filled up from there. So before we talk about the actual developments from 2023 pertaining to federal Indian law, I just want to give a bit of background, a little bit of foundation, because I'm sure those of you attending today or listening in the future on YouTube might have varying levels of experience or knowledge of federal Indian law, maybe none at all, maybe quite a bit. So I just want to share first and foremost that the federal government's authority regarding Indian affairs can be traced back to the federal constitution that was ratified in the 1780s. So there are 2 places. The first comes in Article 1, the second Article 2, where the federal government derives its authority. And over the course of the last 230 plus years, the scope of that authority has kind of expanded and contracted with different things going on in American government and American society. It depends a lot on who's occupying the White House, who's making up the Supreme Court, who is in Congress, and what Congress is focused on at that particular moment in time. But Article 1, Section 8 of the Constitution sets out the Indian Commerce Clause. And in Article 1, really sets out Congress's enumerated powers. So Section 8 of that article is the Indian Commerce Clause, which empowers Congress to regulate commerce with Indian tribes, states, and foreign nations. And that's the language that the Constitution uses. It specifically sets out Indian tribes as something distinct from states or foreign nations. And that's going to be important in a moment, I think in the next slide. Article 2, Section 2 is the treaty clause, which gives the President of the United States the power, by and with the advice and consent of the Senate, to make treaties. So many Indian tribes in the United States, even today, not all of them, but many of them, have treaty protected rights. They could be rights to hunt, they could be rights to fish, rights to occupy certain territories for certain reasons. But the federal government stopped making treaties with Indian tribes in 1871. And that was done by an act of Congress. It's what we call the treaty statute. And I wish there was this big glamorous reason for that, but there's not. At the heart of it, I think the House of Representatives was jealous of the fact that the Senate had this great power to approve or reject presidential treaties made with Indian tribes. The House of Representatives didn't have to approve those treaties at all, but they were always asked to appropriate money to fund the various promises made in those treaties. So in 1871, treaty making with Indian tribes in the United States came to a halt. But that was after hundreds of different treaties were made, beginning in the 1770s and going right up until the 1870s. So many of those treaties are still valid in use. I can tell you that Pechanga was a party to a treaty negotiation in the early 1850s, but that treaty was never ratified by the Senate, along with about 17 other treaties that were negotiated with tribes across California during the same period. For those of you who are from California or who are really familiar with California history, you might recall that the early 1850s was just a few years after gold was discovered on the American River up near Sacramento. And that was no coincidence that those 18 treaties, which actually promised California tribes, I think, a total of 8.5 million acres of land for themselves, those treaties were never ratified. Congress went into a secret session and voted not to ratify those treaties at the time, but that fact wasn't discovered until 1905, over 50 years later. And many tribes were not even aware of that until after it happened, after the discovery was made. So many tribes in California don't have active treaties or never had a ratified treaty with the federal government for that reason. But in general, the Constitution, Articles 1 and 2, are the sources of the federal government's authority to regulate Indian affairs. We also have a body or a collection, if you will, of 3 Supreme Court cases that are collectively known as the Marshall Trilogy because they were all authored by the Chief Justice of the Supreme Court at the time, John Marshall. And I wish I could go into all of the details because they're rather interesting, but I'm just going to give you the Cliff Notes version, what the holding means for federal Indian law in each of these 3 cases. The first of which, Johnson versus McIntosh, was decided 200 years ago this year. So that's kind of a double whammy. It's not part of the reason we're giving this presentation, but it is a significant anniversary for a decision that's really been troubling, to say the least, for tribes over the last 2 centuries. Johnson v. McIntosh was really a property dispute between 2 private citizens. There was no Indian tribe or Native American involved as a party to this case. but the Supreme Court came out with a decision that essentially said that title to the land goes to the Christian nation that discovers it. And this was known as the original principle that the Supreme Court articulated. And the Supreme Court didn't think it was making new law. I believe the Supreme Court just felt, and Chief Justice Marshall, the author of the opinion, just thought that he was articulating what everybody knew at the time, that to the discoverer goes title to the land. But as most of us know, I think hundreds of thousands, if not millions, of indigenous people occupied the Americas before Europeans ever stepped foot on these continents. So the decision actually went one step further and said that while Native Americans do have a right to occupy the land, they didn't have the right to alienate or sell the land, because that right is reserved for the discoverer. So this case could be, and this is an oversimplification, but I don't think it's far off the mark. This case does stand for the proposition that Native Americans, according to the Supreme Court's holding in Johnson versus McIntosh, were divested of their legal right to the land they had occupied for millennia. And by the way, Johnson versus McIntosh has never been overruled. Okay, it's still good law on the books. Cherokee Nation versus Georgia, a decision decided about 8 years later, obviously involved an Indian tribe, Cherokee Nation, which at the time, the 1820s and the early 1830s, was in some respects similar to the United States, in that the Cherokee Nation had a 3-branch system of government. The Cherokee Nation had a very active newspaper, the Cherokee Phoenix, which is still in print today in both English and in Cherokee, because the Cherokee had, starting in the 18 teens and 20s, its own syllabary. But the Cherokee Nation was seeking to challenge a series of laws passed by the state of Georgia that were affecting it and its people on the Cherokee reservation. And keep in mind what I said before about the Constitution. The Cherokee Nation had a reservation within the boundaries of Georgia because they negotiated for that reservation with the federal government under the Indian Commerce Clause and the Treaty Clause of the Constitution. Georgia was not a party to that treaty in any way, shape, or form, but yet Georgia was passing these laws, really trying to make it difficult and unpleasant for the Cherokee people to continue living on that reservation because there were rumors of gold on Cherokee land. So the Cherokee Nation, which was politically savvy, and as I said, similar to the United States government in several respects, but its own distinct government, tried to challenge Georgia's laws at the US Supreme Court. The Supreme Court came back with a decision that said, look, the Cherokee Nation cannot do that. Because when the Supreme Court reads the Constitution, Article 3 tells us who can sue whom and who can be sued. And there's a lot of language in the Constitution of one citizen suing another citizen, a citizen of one state suing a citizen of another state, states suing each other. But there's no language in the original text of the Constitution about an Indian tribe suing anybody at the Supreme Court. So the Supreme Court in this case came back with a decision that said Indian tribes are neither foreign nations nor states. That's why they were listed separately in the Indian Commerce Clause. And in fact, the Supreme Court said they were something totally different. They were described in this decision as domestic dependent nations. And to my knowledge, that was the first time that phrase had ever been used to apply to Indian tribes. That the Supreme Court was really saying that they were domestic because they were within the borders of the United States, and in fact, states and US territories. They were dependent on the power of the United States government, at least in the Supreme Court's mind, but they were also nations in the sense that tribal governments had the ability and the authority to develop rules and make laws for their people to follow. So, in a sense, this case was decided on procedural grounds. The court never really reached the merits challenging the Georgia laws. It got to those merits in Worcester versus Georgia. Worcester was a private citizen, a non-Indian, who was working on the Cherokee Reservation as a missionary. So some of the laws that Georgia was passing to make life unbearable for people on the Cherokee Reservation actually affected Mr. Worcester. And he had standing to challenge these laws. And the Supreme Court came back with a decision that was a win for tribes. The Supreme Court recognized that the tribe had negotiated with the federal government for that reservation, that the tribe was not only capable of passing laws to regulate its members, but was in the active process of doing so. And it ultimately held that the laws of the state of Georgia could not apply on Cherokee land, which this decision is also still good law today. In general, the laws of the state do not apply on Indian land, or what we call Indian country. That's a term defined by statute, but it includes, among other areas, Indian reservations. So now we have the Constitution, we have the Marshall Trilogy, and in 1 hour, I really can't do federal Indian law justice. This is something that usually takes a semester, but this is a very brief overview of federal Indian law, and I think it will inform the next slides coming up, significant developments just from this year in the field of federal Indian law. At least I hope so. So the first one, and probably the most well-known from 2023, is a decision that made its way all the way up to the US Supreme Court. The decision, it's been known by several names over the years, but ultimately Brackeen versus Halland. Brackeen is the name of a couple, husband and wife from the state of Texas, and I'll give you a little bit of background in a moment. Halland is the name of our current Secretary of Interior, Deb Haaland, who is the first Native American woman to occupy that office. She is a citizen of the Laguna Pueblo in New Mexico. She formerly served in the House of Representatives before her appointment to Secretary of the Interior. And by way of background, this case involves a non-native couple, Chad and Jennifer Brackeen, who sought to adopt a child. This child happened to be Native American with ancestry from the Navajo and Cherokee nations. Now, those are two separate and distinct sovereign Indian tribes located in different states. The Navajo Nation is based in Arizona. The Cherokee Nation is based in Oklahoma. And Mr. and Mrs. Brackeen, as I said, were a Texas couple seeking to adopt a child in that state. Because of a federal law known as the Indian Child Welfare Act, the tribes had an opportunity to be involved in this adoption case and to make a recommendation about where this child should be placed. And the tribes together felt that it was best that the child go to a tribal home out of state rather than with the Brackeens. The reason being is because a tribal home is believed to support tribal culture and tribal sovereignty, so that the child can grow up in a place where cultural values would be shared freely and supported. Now, a little bit of background here. The reason that there is an Indian Child Welfare Act, and there has been since 1978, is because the United States government had a very public, maybe not well known, but it was publicized and official policy of promoting non-Indian adoptions for Indian children in the 1950s and 60s and early 70s. And that, by the way, followed on the heels of another policy called the boarding school policy, which began in the 1870s. The federal government of the United States was quite candid in encouraging and pushing Native American children to go to boarding schools away from their homes, away from their communities, away from their cultures, so that they could be assimilated into the dominant society, so that they could learn a trade, they could be instructed in English and basic math, and after their graduation, they could be apprenticed into a business or some kind of service role in the community. Sometimes these children went back to their communities. Sometimes they didn't make it. They died while they were at the school. And most of the boarding schools that I'm familiar with historically did in fact have cemeteries there where these children were buried. But the Indian Child Welfare Act was passed by Congress in the 1970s, specifically to promote tribal involvement in these cases and ensure that Indian families stay together, which had been the opposite of the federal government's policy for generations. Okay, so Navajo and Cherokee wanted to see this particular child be placed with, or in, I should say, a tribal home, the home of a tribal member. That tribal home ended up backing out for whatever reason. So the adoption went forward. Chad and Jennifer Brackeen adopted this child and then later adopted one of the child's siblings. So you might think, well, that should have ended the situation. How did we end up with a court case? And by the way, the adoption happened before the decision was finalized. The Brackeens believed, and they had support from outside sources, including a couple of organizations that put their money behind this feeling, behind this legal argument. They believed that the Indian Child Welfare Act, a federal law that requires higher evidentiary standards and encourages tribal participation in cases involving Indian children, certain cases, but adoptions definitely, and also cases that stem from child protective services, what we might call dependency cases. The Brackeens argued that the Indian Child Welfare Act was just an example of reverse discrimination. And their argument really honed in on one particular provision of the act known as placement preferences. So the Indian Child Welfare Act applies when you have an Indian child who is a person under 18 who is a member of a recognized tribe, a federally recognized tribe, or who is eligible to be a member of a federally recognized tribe and is the child of a tribal member. But when that child cannot be returned home on command, that child has to be placed in the home of an extended family member, of another tribal member, another member of the child's tribe, or in another Indian home, unless there is good cause to deviate from those placement preferences. Now, most of us, not everybody, most of us would argue that this is not a racial question because members of Indian tribes are dual citizens. They are citizens of the United States, but they are also citizens of their tribes. That is a political, not a racial classification. And, you know, what you learn quickly taking a class on federal Indian law or practicing in the field is that that is an okay classification. That's a political, not a racial classification. The federal government of the United States even has a hiring preference for members of federally recognized Indian tribes, and the Supreme Court has upheld that preference because it is based on a political classification rather than a racial one. It's not based on ancestry, it's based on whether or not you are a member, a citizen of a sovereign tribal nation, which is what this child is. So Chad and Jennifer Brackeen took issue with the third preference, placing the child or a child in another Indian home. They argued that really that is race-based classification because it could be any tribe, it could be a member or a non-member, it's just not defined. They brought this case in a district court in Texas, and back in, I think, October of 2018, I remember where I was when I heard about the decision. That district court judge issued a decision finding the Indian Child Welfare Act unconstitutional and triggering a chain of events that culminated in a Supreme Court decision just this past June. This case was unlike any I had seen before. I only know of 3 cases directly dealing with the federal, the Indian Child Welfare Act that have gone up to the United States Supreme Court. One in 1989, one in 2013, and then this one, Brackeen v. Howland. And I must say it got a lot of attention as it deserved, but it really made for a dramatic showdown in a lot of ways. As I said, there were a couple of private organizations who were supporting the Brackeens through this process. The Goldwater Institute, probably being the most famous among them. We have a couple of states who got in the fray. The states of Indiana and Louisiana and Texas were both on the side of the Brackeens, or were all on the side of the Brackeens, I should say, opposing the Indian Child Welfare Act as a race-based law and therefore unconstitutional. Now, on the other side of the coin, we had an incredible outpouring of support from tribal governments across the country, as well as more than 24 states attorney generals or generals. 24 of them, but I have to say, and you know, I am kind of biased, but 497 tribes across the United States out of a total of 574 federally recognized tribes came out to support the Indian Child Welfare Act in one way or another. 5 tribes were actually parties to this case in defense of the Indian Child Welfare Act, while the rest of them supported the Indian Child Welfare Act in amicus briefs. And all 109 federally recognized tribes in California signed on to one of those briefs prepared by the Native American Rights Fund. And I don't know of any case that got so many tribes on the same page to support one issue. But it was really, really impressive. And as you'll see in a moment, it paid off. A lot of people were worried about what was going to happen. There was much talk over the last couple of years about the changing dynamics on the US Supreme Court. There is now, and I think it's pretty much accepted, that there is a political conservative majority on the Supreme Court. And a lot of us were worried that that spelled trouble for the act. But as it turns out, the Supreme Court handed tribal communities and the Indian Child Welfare Act an incredible victory this year. In a 7-2 decision, the Supreme Court found that, number one, Congress acted within its federal power under the Constitution to pass the act in 1978. It also rejected the Brackeens' argument that the Indian Child Welfare Act is a form of the federal government commandeering states. The court rejected that argument. They also rejected the argument that not on the merits, but they rejected the argument that the Indian Child Welfare Act violated the Equal Protection Clause of the Constitution, finding that the Brackeenes didn't have the standing to raise that issue. In other words, it was not properly before the US Supreme Court in this case by this party. 7-2. I mean, most of us, myself included, I think, thought that the best case scenario was we were going to get a 5-4 decision. 7-2 just blew my mind. There were two dissenting opinions, Justice Thomas and Justice Alito, who just flatly argued that the Indian Child Welfare Act was unconstitutional. And that wasn't really a surprise. Justice Thomas kind of tipped his hand back in the baby girl case 10 years ago and said about the same thing. So I wasn't surprised that he was a dissenter. But it's important to note that none of the other 7 justices joined in their opinions. So, you know, I took that as a good sign. Justice Kavanaugh issued a concurring opinion with the majority, where he said, I agree, but this equal protection issue, yeah, it's still out there. We haven't fully addressed it because it's not properly before the court, but it's something to kind of keep in the back of our minds. If you're going to read a decision, the majority decision, you know, it was by Amy Barrett Cohen, Amy Barrett, and she was thoughtful and clear, but I have to say, Justice Gorsuch's concurring opinion was, he hit it out of the park because he really took a deep dive into the history behind the Indian Child Welfare Act, why Congress thought we needed it in the first place. He addressed the Indian boarding school policy. He addressed the adoption policy of the 1950s and 60s. He talked about the rights of tribes and the authority of Congress under the United States Constitution to pass this legislation. And he was very eloquent in doing so. I just want to read to you one paragraph or a part of a paragraph, if I may, because I really think it's a nice synopsis to what was a very ugly, very public legal showdown. He ended his 38-page concurring opinion with these words. Often, Native American tribes have come to this court seeking justice, only to leave with bowed heads and empty hands. But that is not because this court has no justice to offer them. Our Constitution reserves for the tribes a place, an enduring place in the structure of American life. It promises them sovereignty for as long as they wish to keep it, and it secures that promise by divesting states of authority over Indian affairs and by giving the federal government certain significant powers aimed at building a lasting peace. In adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history. All of that is in keeping with the Constitution's original design. I thought that was beautiful and right on the money when you take this law in context and understand its history. So that got a lot of news, and that's actually going to inform the next thing that I'm going to talk to you about today. Protecting the Indian Child Welfare Act it's not over, okay? The decision in Brackeen just kind of reframed the issue. Okay, now we know that the Supreme Court upheld the Indian Child Welfare Act. We know that the current Supreme Court believes that Congress had the authority to pass it under the federal Constitution. What next? Well, we have to keep in mind that there are still people out there looking to challenge the law. There are still organizations like the Goldwater Institute with deep pockets who disagree with the Indian Child Welfare Act and will look to attack it at any turn. And we know that the Supreme Court of the United States will change in its makeup in the future because that's what the court does. So while we are able to take a breath, those of us who work for tribes or support tribal governments and Indian child welfare in general, we also have to keep an eye out for this equal protection issue and realize that this is probably going to come up in one way, shape, or form again. So I know that there are a lot of organizations and tribal attorneys here in California that have kept their eyes on this situation. And yes, they too were relieved at the outcome of the Brackeen case, but they realize that there is still more work to do. One form of that work, or I should say one spokesman who's speaking up for these concerns, is an assemblyman in California named James Ramos. He's also the first Native American in the assembly. He's a member of the San Manuel Band in San Bernardino County. And he's introduced AB 81, which is a bill to update the California Welfare and Institutions Code to be what we would call the California Indian Child Welfare Act, or CICWA. Before the Brackeen case was decided, Assemblyman Ramos thought this was going to be corrective action if the Supreme Court struck down the Indian Child Welfare Act. We don't need to do that, so the urgency is not quite there anymore. So this became a 2-year spot bill. It's still in the works, and we hope to see it realized in the future. But what it's supposed to do is tighten up the language of the Welfare and Institutions Code to include some protections beyond what the federal Indian Child Welfare Act already says. And I've seen a lot of tribes, or excuse me, not tribes, but a lot of states kind of thinking about such things in the wake of Brackeen. As a matter of fact, I know that the Uniform Law Commission, which is a non-partisan body created to draft uniform laws that states can or may choose not to adopt, but just to draft models to be out there for their reference, for their use. And it's something that I'm working on with them, just because Pechanga is concerned about future attacks on the Indian Child Welfare Act, not just in California, but in other states. And this would be taking the federal Indian Child Welfare Act and maybe tweaking it a little bit to address possible concerns that came up in the Brackeen case, concerns that practitioners in the field have identified, maybe borrow language that's been used by certain other states, because the federal Indian Child Welfare Act is kind of a baseline. That law applies across all 50 states, but states are free to adopt their own laws that build upon that baseline. California has done that. As AB 81 would just kind of like tweak the language a little bit and maybe address some of the issues that came up in Brackeen. And we're probably going to see that in other states. I know that leading up to the decision in Brackeen, which came out in June, states like North Dakota and Wyoming passed their own state versions of the Indian Child Welfare Act. And they might tweak those again in the future now that we have a decision. Changing gears a little bit. I see that we have about 15 minutes and I want to make sure to address the questions that we've been getting in the chat. We're still talking about Assemblyman Ramos, and we will, I think, in the next slide as well. AB 44 is totally different. We're moving away from child welfare, and we're talking about tribal sovereignty in the context of law enforcement. So as I mentioned, Pechanga is very fortunate to have the Pechanga Rangers, our law enforcement department here on the reservation. And there are probably 25, 30 tribal law enforcement departments across the state and maybe 20 or 25 different tribal judicial systems. The point is, not every tribe has a law enforcement department, and not every tribe has a judicial body. But AB 44 was intended to offer to tribes in California, federally recognized tribes, that is. And if you're not familiar with that phrase, it simply means those tribes, the United States of America considers itself having a government to government relationship with. Okay. 574 recognized tribes across the country, 109 of them are here in California. The Pechanga Band of Indians is one of those recognized tribal nations. So AB 44, introduced by Representative Ramos, was intended to offer access to CLETS, the California Law Enforcement Telecommunication Systems, to federally recognized tribes within the state. Why is that important? Cooperation and collaboration between tribal law enforcement bodies and local law enforcement is essential for public safety. And I don't mean public safety for me or for the tribe, for everybody's public safety, okay? Because nobody wants to see their people, whether they're tribal members, state citizens, visitors, guests, casino patrons, employees, anybody. None of us want to see people hurt by crime. So the best way to deal with crime and to maybe prevent future crimes is to share information and resources when that's possible. So CLETS is a system that's been around for years and years, but tribal police agencies have not had access to it until now, thanks to AB 44. Now, this might sound all well and good, and it is, but there is a concern, so to speak. When I first learned about this law's passage and actually read the text, there is a provision in AB 44 that requires, and it's a minimum requirement. In other words, if a tribe in California, a federally recognized tribe, wants CLETS access, that tribe must waive its sovereign immunity. Sovereign immunity is a protection from suit, and the federal government, the Supreme Court of the United States, has long held that tribes have sovereign immunity predating the Constitution of the United States. That sovereign immunity can only be waived by the tribe itself or by Congress, neither of which has happened here. So the state of California, in passing AB 44, is basically telling tribes in California, if you want access to CLETS, you have to waive your sovereign immunity. And that's a condition that leaves a bad taste in the mouth of many tribal governments. So, you know, I don't presume to speak for Pechanga here. You know, I don't presume to speak for other tribes or advise them what to do. That's a decision each tribe will have to make on its own. But it is a provision that I feel comfortable saying most tribes probably wish wasn't in the bill. But like all pieces of legislation, it's a product of compromise. So it's just something to be aware of. If you work for a tribe, if you work with tribes, this access is going to require a waiver of sovereign immunity on the tribe's part. But still a step towards information sharing and making sure that tribes have what they need to protect their people. AB 389, also introduced by Representative Ramos, is slightly different. Well, it's quite a bit different, actually, but it too was signed just this fall. And this is meant to protect cultural resources and human remains. So the law requires the California State University system, the biggest public state school system in the country, to comply with the California Native American Graves Protection and Repatriation Act of 2001, which was inspired by the federal NAGPRA law passed by Congress in 1990. What you need to know about NAGPRA and CalNAGPRA is that these laws were meant to require encourage and require organizations and institutions receiving public money to return human and cultural remains in museums, in laboratories, in exhibits to the native peoples that they came from. The tribes, the individuals whose ancestors' remains were taken, on whose lands these remains were discovered. And, you know, over the course of American history and history at large, unfortunately, there has been quite a large market for Native American remains, trafficking those remains, cultural items, items of religious and cultural significance. And under the 1990 NAGPRA, a lot of these institutions were required to collect and assemble inventories of the remains and resources in their possession and then repatriate or return them. That hasn't always happened. In fact, 30 years later, a lot of institutions and well-known schools across the country are still not fully in compliance with the federal law and are seeking to comply with the California law. Excuse me. So among the more important provisions of AB 389 are prohibiting the use of Native American human remains or cultural remains for teaching or research purposes at the within the Cal State system, requiring Cal State campuses to report to the legislature every year on its progress in implementing these measures, reviewing their collections, consulting with local tribes, and then repatriating human remains and cultural items. The Cal State University system must monitor campus efforts to review their collections and require completion of these inventories by December 31st, 2025. That's coming up. When you consider that some institutions have not yet fully complied with the 33-year-old NAGPRA, the fact that the state of California is now telling the Cal State system that it must comply with Cal NAGPRA, or at least the inventorying part by the end of 2025, that's a pretty short deadline. But if they haven't done it so far, they should have known that this is a requirement. And then finally, the Cal State University system must engage in meaningful and respectful consultation with Native American tribes regarding protocols for handling and identifying Native American remains and cultural items. That provision by itself is not new. We have an executive order from the governor requiring such consultation, but this is underscoring it in AB 389. Okay, so we're hopeful that this will encourage the Cal State system to follow through on its requirements and mandates. The last thing I'll leave you with, the last substantive slide, and I will hang around for questions if you do, is just two programs that were introduced this year by the California Department of Social Services. One of them is the TDR program, which stands for Tribal Dependency Representation. So for those of you who are familiar with dependency law in California, this is when social services in any county within the state removes a child and files a petition in state court to encourage the family of that child to go into services, go into rehabilitation, take domestic violence classes in order for it to be safe to return the child to that home. When you go into a dependency courtroom, Indian tribes who under the Indian Child Welfare Act are entitled to be involved as parties and entitled to access to documents and to address the court. Indian tribes are the only parties to those cases who are not offered court-appointed counsel. Minors get counsel, parents and guardians get counsel. Social services agencies have county counsel to represent their interests, but there is no one to represent the tribes unless they have their own funds or have their own in-house attorney, and many do not. So under this program, there is money available to tribes, federally recognized tribes in California, that they can get reimbursed for the cost of hiring legal counsel or paying their in-house counsel to represent the tribe's interests in state dependency cases. Okay, that's a good thing. And quite a few tribes, I think over 60, took CDSS up on this offer. So that's important. The funds, as I said, they can be used to retain outside counsel, to pay in-house counsel, but it's a good program, and looking ahead, that program is going to be offered again in the next couple of fiscal years. The invoicing process for the 2022-2023 fiscal year, I believe, is now over, but tribes can still opt in if they've not already done so for the current or future fiscal years. And the TAH program, that is the Tribally Approved Homes program. This offers funding to California's federally recognized tribes to reimburse them for the costs associated with recruiting, protecting, preserving, and approving tribal foster homes. This is a big deal because not all tribes have the funds to do this, not even tribes with gaming revenue. If you don't have tribal families willing and able to act as foster families to young children, those children can then be disconnected from their tribal culture before they return home, or if they get to return home. And that's what tribes don't want to have happen. They want that continuity of culture in place, even in foster care. If the child cannot go home, tribes generally want the child in a home that supports and promotes their cultural values, their history, their language. And I can tell you, I practiced in dependency court for a number of years, often in Los Angeles County. Los Angeles County, according to the 2020 census, has 156,000 people who identify as Native American. And the last time I checked, LA County has exactly one tribal foster home. One. And that foster home was never available on any of my cases. So we would always have to find other people, family members if possible, but other people, other homes to place these children if they could not go back and if there were no homes available on the reservation. So these awards, they can be larger than the TDR awards because there are fewer tribes participating. Not all tribes have social services departments. Not all tribes have their own social workers. And the program is prospective. In other words, yes, the tribes, if they participate in the TAH program, they can get reimbursed for their costs, but the tribes had to provide a budget to CDSS, telling CDS kind of what they were thinking of doing with the money. And many tribes have done that. And again, that's an ongoing program. So tribes that have not participated yet will, I think, have the opportunity to do so in the future. So as you can tell, a lot happened in 2023 on a federal and a state level with regards to federal Indian law. And I know this was a lot of information coming at you in 1 hour, but I do hope it was interesting. I hope you took something away from it. And I also invite you to reach out to me if you have questions or there are things you think maybe we can collaborate on. But my work number and my work email are there on the screen, and I look forward to hearing from you. Lisa, do we have a couple of questions in the chat?
We do. Let me read a few of them so you can address them. And again, folks, it is nearing 1 o'clock. If you need to leave, we certainly understand that. But anyone who wants to hang out, we do have some good questions here. So one comment just to start out, Mark, was Allison just wanted to let you know she appreciated your primer on Indian law as someone who doesn't practice in the area. So she just wanted to thank you for that.
Thanks, Allison.
And let's see here. We have an attendee who wanted to know how you envision the posture of future challenges to ICWA under equal protection, if you have any sense of that.
It's a really good question. I think there are people behind the scenes, people in organizations who are maybe out there looking for the right couple, the right case where there is an equal protection argument. So if it didn't work in the Brackeen case, maybe it would work in a case with other factors, other circumstances. I know that's going on actually. And I think this is part of the push for the Uniform Law Commission, for other states, and for tribes to try to get in front of the ball and deal with that issue. I think we're going to see more litigation related to those placement preferences. That seems to be the language in the Indian Trial Welfare Act that draws the most ire from people. And I think the notion of those placement preferences is good, but I do think that third placement preference could be tied up in a way, or tightened up, I should say. So now the Supreme Court is clued into it. I don't think the Supreme Court has an appetite to take another ICWA case in the near future. But I do know that there are going to be people working on the state and district court level to get this case, an equal protection case, in front of a judge. And it might take a few years, but they're going to try to get it back before the Supreme Court. So if states adopt their own laws and deal with the possible equal protection arguments on the front end, it might reduce that litigation. But we don't really know what's going to happen. That's just my guess.
And we also have a couple questions about practicing in the area of federal Indian law. We have an attendee who said, "Thank you, Mark. Great presentation. What is the best way for a new lawyer who has never practiced to begin working in the area of federal Indian law, volunteering perhaps?" So
it's a good question.
Yeah.
And for someone who's already licensed to practice law, my recommendation would be to join the California Indian Law Association. It's a body made up of attorneys who practice in this field and or are interested in this field, because, and I should have said this at the outset, I am not a Native person. I'm not Native American. I do not identify as Indigenous. But CELA would give you updates. They have a lot of great resources. They have an amazing conference every year. It's usually in early October, but it's a great way to find out what these issues are and who plays a role in them. I know that here at Pechanga, we are actually actively looking for an intern, a 2L already in law school for next summer. And several tribes, local tribes in San Diego and Riverside counties do that. I know that federal Indian law is offered at Thomas Jefferson, and I think sometimes Cal Western schools of law. So occasionally they have events. San Diego State has a very strong American Indian Studies program. And we have in San Diego County in Valley Center an intertribal court, a consortium court that's made up of, I think, 14 member tribes, and they have their own bar association if you want to represent tribal members of those tribes or the tribes themselves in tribal court. So you can Google the Intertribal Court of Southern California to find the paperwork and the dues. But there are a lot of resources available, and I'd be happy to connect with people offline about other resources. But
that actually, Mark, what you just said about the intertribal court bar ties into another question we had, which is, can someone who is licensed in another state practice federal Indian law in California? Because it's federal. It sounds like maybe you even need another licensing through the court to do that.
You may. It depends which court we're talking about.
Okay.
So in California, they've changed the rules so that if you represent a tribe out of state that is a party to a case in California state court, you do not have to go through the pro hoc vice process. If the tribe designates you as their legal counsel, you can represent the tribe in California state court. In tribal court, it's a little different. It depends on the rules of each particular tribe. But I know that in here at Pechanga, we've had a couple of different out-of-state attorneys representing parties in Pechanga tribal court. But again, our rules allow for that. So it would be up to each tribe. But it's really kind of interesting. So I've been a member of several tribal bar associations, but I've never had to join an outside state bar to represent my tribal clients. I hope that's responsive.
Another question relates to AB 44. We have an attendee who is wondering about the sovereignty waiver requirement. Could it be regarded as an individual exception that doesn't destroy their immunity in other circumstances? Do you have any information about that?
Could you repeat the question, Lisa?
Yeah, I'll read it as written. Can this waiver requirement to sovereign immunity in AB 44 be regarded as an individual exception that does not destroy the immunity in other circumstances?
I see. It's a good question. And I think that's part of the rub of it. It could be read as a limited waiver just for this specific situation and instance. So the waiver, it's like the state is inviting the tribe to enter into this agreement. So the waiver would be for the state to protect itself and enforce its requirements against the tribe for the sake of CLET's access. So to the participants' question, I think yes. But I think tribes are still worried about the language because oftentimes when I've helped tribes on contracts, especially dealing with waivers of sovereign immunity, the goal is to try to make them as limited as possible so as not to expose the tribe to unnecessary or unforeseen liability. Okay, and tribal sovereignty is so important to tribes because there have been so many attempts to erode it over the last couple of centuries, but I think it can be read that way. I would like to trust the state that they too regard it as a limited waiver of sovereign immunity, but on the other hand, it's still a concern because it is a condition. It's not even a matter of an individual negotiation between the state and one tribe. It's just a condition, and I think a lot of tribes were taken aback by that part. I was.
So we have several more questions. If you can still hang out, Mark.
Yeah.
If you can't.
Yeah.
With regard to that bill related to the California State Universities and the cultural resources requirements, does it cover the UC campuses, the University of California?
I believe it does. And I will say, because I'm an alumnus of a UC school, I will say, and I didn't mean to throw shade at anybody, but doing the inventory, collecting all of this information, preparing these reports, this is not something that will take a weekend. Some campuses don't even know what they have. They have boxes of things that maybe weren't properly documented or recorded. And when I was at UCLA, 22 years ago, they were still in the process 11 years after Congress passed the federal NAGPRA in preparing their inventories. So, I believe it applies to both. And I believe this is an ongoing process, but this is meant to stoke some expediency in the process because it's been going on for such a long time. And I will say this, not here at Pechanga, but in my previous position, I had the opportunity to be involved in a case between several professors and a UC campus, a particular campus, over what to do with with human remains. And the campus was trying to comply with the law and repatriate those remains to the local tribes. The professors in that particular case felt there were still questions to be answered by DNA testing those human remains. Those human remains had been in the custody of the campus for over 30 years. And the court ultimately sided with the campus, and the repatriation went forward. The professors, in other words, could not stop it. They did not have standing to do that. The law was upheld and the repatriation was appropriate. And I think that's part of the concern. Like these, some of it is not knowing what's in our own collection, but some of it is, I think, a desire to continue DNA testing, as that testing has been developed and enhanced over the years. But it's still incredibly invasive, and these remains have been separated from their people, from their histories for years, decades, centuries.
So we have a comment here from Angela. Thank you, Angela. She wanted to kind of chime in on some resources for people who are interested in this practice area. She's saying check out Turtle Talk online for resources, and also that USD School of Law will be offering a course this coming spring. And she also wanted to make sure everyone knew about the Native American Lawyers Association in San Diego, www.nalasd.org. That's nalasd.org. Thank you very much for that, Angela.
And I think I know Angela, and Angela herself is a great resource. Thank you for sharing.
I think we'll just take this one final question and wrap it up. How are tribal law enforcement, courts, and tribal social services funded?
Oh, that's a really great question. Well, they are funded generally by the tribes, and as I said, not all tribes can afford that. It's expensive, and tribes do what they can, and of course they have to consider their resources. Also, they have to consider their tribal populations, because you might need multiple social workers to, cover hundreds of people. You might need a few more than that for thousands of people. But there are also grant opportunities, state and federal grant opportunities out there for tribal courts. The BIA offers tribal courts one-time funding, which is kind of a misnomer. They say one time, that makes it sound like one and done, but it's annual funding. Tribal courts can apply for that funding on an annual basis, even if they received funds in the previous year. Law enforcement, social services, they can do the same thing. There are what are called CTAS grants. So tribes considered as states, they can get funding that way, and I know some tribal courts are. So there is money out there. And then, of course, tribes that have regular revenue streams, can fund some of those resources into their own tribal departments. But, tribal social services, tribal law enforcement, they are good at not only keeping people safe, but also infusing, or I should say, informing their work with tribes' cultural values. And that's so important. And when it works, they are collaborating with their state counterparts, right? Because take Pechanga, for example, we have many tribal members who live off reservation. We have tribal members in 30 different states. So very often our tribal law enforcement officers, our tribal social workers are communicating with social workers and law enforcement officers offsite for the well-being of our tribal members, wherever they might be. So there is funding out there for that, but there almost never seems to be enough funding. It is expensive to pay salaries, to insure people. And, you know, as I said, you know, it often depends on how much land a tribe controls, how many members it has. So those are all factors to take into consideration.
All right, well, with that last question, I think we'll wrap things up. And Mark, you might want to put up your last slide again, just for anyone who may want to try to get in touch with you. Mark is kindly providing his information. So any questions we didn't get to, or any questions that you might think of, feel free to reach out to Mark. He's been very generous with his time today. And thank you for those of you who hung out with us a little bit late. Great presentation. And thank you very much, Mark.
Thank you, Lisa. Thank you.